Hey, George Floyd people. Look, I didn't see this. Somebody sent me this video of motion of hearing to quash subpoena. So this is where the drug dealer, George Floyd's buddy, who was in the car in the store wearing the red and the white, they want him to testify. So I've only listened to like, I think 30 seconds of this. So I'm going to be listening to it cold, but here we go.
Maurice Hall. Mr. Hall, could you spell your names? We've gotten different spellings on your name.
The correct spelling for you guys will be Morrishall.
All right. And representing Mr. Hall today, note your appearances.
Good morning, Your Honor. Adrian Cousins and Jeffrey Eisman on behalf of Mr. Hall.
And Mr. Hall, your attorneys are present. When they address the court, they're going to go to the podium, so you should be able to see them at that time. But obviously we are not in a position where you can consult privately with them today, but you've had a chance to talk to them.
Where is Mr. Hall? The white background would appear that he's in jail, but I don't know if he is in jail or not. But I'd like to know where Mr. Hall was.
Is that correct? That's a yes?
Yes.
All right, thank you. All right, this is
I can't read this in the background, but my guess is he's in jail.
Mr. Hall's motion as a witness to quash the subpoena. Who would like to address it?
Okay, so quash, for those that don't know, is kind of a legal term, and according to
Quash.
it's like a K-W-A-S-H. It's reject or void by legal procedures. Most people, non-lawyers, we just say squash it. Squash the subpoena. And then the lawyers feel all cool when they come back and go, it's quash, not squash. All right, whatever. Basically, you're squashing it. You're stopping it. To quash is to prevent it from happening. So she wants the subpoenas to be quashed, get rid of. She doesn't want him to be in because whatever reason.
Cousins, if you would. And you can take off your mask if you'd like.
Thank you, Judge. Good morning, Your Honor.
Good morning.
Mr. Hall has been subpoenaed as a witness in this case by both the prosecution and defense.
By both. He's a popular guy.
Defense counsel in their opening statement specifically named Mr. Hall and told the jury that they intend to call him and previewed what that testimony they believe would be. So in order...
Who thinks Mr. Hall, who do you think his testimony helps? Does it help the prosecution or does it help the defense? It helps the defense. Because if they can say that he sold the drugs and he gave them to him and he knew and he was a regular buyer and he's been selling the drugs for years and he helps him get it and he makes all these admissions of his culpability within a crime, he shows that George Floyd is a drug head or a drug fiend. So the prosecution doesn't want that. The prosecution wants to make this all about the white knee on George Floyd's neck. So they don't want him testifying. That's why I don't think they're going to give him immunity. They could give him immunity, but we'll see. I don't know how this ends up.
In order to avoid any kind of delay or interruption in these proceedings, I notified all parties that Mr. Hall would be invoking his Fifth Amendment privilege against self-incrimination where he called to testify. I then subsequently filed my notice, my motion to quash the subpoena. Your Honor, at this point...
Okay, so what she did is she notified the parties and said, look, my client's taking the Fifth, so don't call him because he ain't saying nothing. And then that puts the DA on notice to say, well, I don't care. I don't want him taking a Fifth, so I'm going to give him immunity, and then he can sit up here and whatever he says, I promise not to prosecute him on. But I want his testimony. Why wouldn't a prosecution do that? Because they don't want him testifying. They want him to take the Fifth. They got enough to charge him already. They're going to wait till after this trial and then charge him, which is why they haven't charged him now, because they probably don't want him testifying. So they're making him think he doesn't have a case, and he would be probably better testifying and then say they used it against him. He was forced to testify, and he could probably get it suppressed. But whatever. I mean, look, no attorney is going to let their client take the stand and not advise them to take the fifth. So, but remember, and this is what the jury, I don't know if is made clear, the prosecution has the right to give immunity and make him testify. The defense cannot give him immunity and can't make him testify, even though it helps their case. So when she notifies both parties that he's taking a fifth, normally DA and prosecutor be like, if he's going to take the fifth, then cancel the subpoena. We don't need him. I don't want to waste the court's time, my time, for him to come here and take a fifth. Evidently, the defense is probably like, hell no, I want him to get on the stand and take the fifth, because that still helps my case. I'm saying he's a drug dealer, and if he says I don't want to talk to you, that helps my case. So let's see where this goes.
In time, Mr. Hall has no immunity. He has been provided no immunity, no protection for his testimony.
Oh, so she brought out that he's not getting immunity, which is good. The DA can do that. And of course, this is probably happening out of the presence of the jury. The jury isn't knowing any of this
Whatsoever. And because of that, Mr. Hall is invoking his Fifth Amendment privilege against self-incrimination in several key areas of questioning that we believe he would face were he to be called to testify.
So she says in several key areas of it. When you take the fifth, you can't selectively take the fifth on some questions and then answer some. It's either all or nothing. So that's why a lot of people, if your witness takes a stand, they'll just say, I'm taking a fifth on the first question. They don't want to do it. So unless they've changed the rule, that's the way it used to be. I don't know if it's still that way. I guess we'll see.
Bye.
Well, let's stop you there. You said on certain areas that he would testify to. So there are some topics that he would not incriminate him. Is that correct?
Your Honor, I cannot envision any topics that Mr. Hall would be called to testify on that would be both relevant to the case that would not incriminate him.
Your Honor, my client's a freaking criminal. Anything they ask him is going to be incriminating. Man, Hall's getting drugged through the ringer and he ain't even in court yet.
Well, that's ultimately the court's decision, correct?
Yes.
Okay.
But
And that's on a
Yeah, because the court can say, I want him to hear, and I want to hear him say take the fifth. And the court can't hold him in contempt if he takes the fifth. But the court can ask the DA, are you willing to give him immunity for his testimony? I would love for the court to do that in front of the jury. I'm sure the defense would too. Because the DA is going to go, no, his testimony only hurts me. I don't want him testifying. Well, he won't say that.
question by question basis. Is that correct?
Yes, Your Honor.
Okay. All right. Go ahead. I interrupted you.
No, that's okay, Judge. And just for brevity, I wanted to outline those areas that I believe Mr. Hall may face questioning. The first area where he would be invoking his privilege against self-incrimination is any activities that took place on May 25th, 2020, both before and after police arrest.
Well, they got him on video throwing drugs. And they've got his girlfriend saying they bought drugs from him, and George brought drugs from him several times. And he was in the car with him. And there was drugs in the car. So, of course, he doesn't want the drugs tied to him. And he doesn't want to say that he threw and hid drugs and answer. Of course he doesn't want to answer those questions. It only hurts the case when the DA charges him.
Arrived.
Okay.
Mr. Hall's testimony in these matters would specifically put him in the position of being in very close proximity to Mr. Floyd. There's an allegation here that Mr. Floyd ingested a controlled substance as police were removing him from the car.
If they can tie the drugs that he sold him to his death, guess what? Hall could be facing homicide, manslaughter charges. So no attorney is going to let him testify.
A car, by the way, that has been searched twice, and to my understanding, drugs have been found in that car twice. This leaves Mr. Hall potentially incriminating himself into a future prosecution for third-degree murder. And specifically, that's 609.195
Oh, so she covered it. It's third-degree murder, I guess.
subdivision B. And that statute, as the court is well aware, covers third-degree murder liability for someone who is involved in drug activity that eventually leads in an overdose. And that statute is broad, Judge. It does not just include the situation where A sells drugs to B, B then succumbs to an overdose.
I got news for you, attorney. He's probably getting charged with that anyway, whether he testifies or not. Maybe. He may get a little privilege somewhere.
In fact, it includes any activity directly or indirectly, unlawfully selling, giving away, bartering, delivering, exchanging, distributing, or administering a controlled substance classified as Schedule 1 or 2.
Well, then his girlfriend should be charged with third degree. Why isn't the girlfriend charged? She admitted to buying and doing drugs with him, and sharing drugs, and supplying drugs.
So that statute is broad, Judge, and it has been interpreted broadly by Minnesota courts. Again, it's not just that A and B situation. In fact, anyone who can be pointed to as a link in the chain of distribution, someone who prepares drugs for someone else, someone who acts as a go-between, can be implicated in third-degree murder.
Someone who's his
so any of
girlfriend.
the activities that Mr. Hall would be testifying about throughout that day, and including before police arrived on May 25th, 2020, could potentially incriminate him in that charge.
I mean, she's acting like this is a big critical thing. It's not that big of a deal. He shows up and he takes the fifth. Big deal. So what? He takes the fifth. He doesn't answer. He doesn't incriminate if he takes the fifth. She's acting like if they get him on a stand, they may trip him up or something. I mean, she's going to be there if he's on a stand. She can object and protect her client. I'm not sure why she's acting like this is the end of the world if he has to come.
Not to mention drug sale and drug use. Additionally, the other area of testimony in which Mr. Hall would be invoking his Fifth Amendment privilege is any personal knowledge that he has of drug use by George Floyd up until and including.
Who thinks Mr. Hall hired her, or if she's a public defender paid for by taxpayers? Raise your hand if you think Mr. Hall hired her. Well, you're an idiot.
May 25th, for the exact same reason, Judge. It leaves him open to exposure on a potential future third-degree murder charge. Any testimony regarding his activities with Mr. Floyd could leave him open to potentially incriminating himself.
Right. I think what I'm going to do is ask Mr. Nelson to list for the court the topics and areas and whether there's something outside of what you just outlined.
The defense wants this guy to testify. So the defense doesn't care about incriminating him. He just wants him to testify because it helps his case. Prosecution does not.
So, because maybe there is some common ground there. So if you could just switch places.
Your Honor, it would be the defense intent to inquire of Mr. Hall as to the following. Certainly, any events leading up to Mr. Hall and Mr. Floyd's arrival at Cup Foods earlier in the day, where they were, what they were doing.
Notice he's not mentioning the drugs. He's trying to make it to where it's non-incriminating, so the judge will order him to come in.
Mr. Hall's interactions with Mr. Floyd in the Cup Foods, including whether either party gave the other a counterfeit bill, whether or not Mr.
Counterfeit bill doesn't expose him to third-degree murder.
Hall gave, sold, or otherwise provided Mr. Floyd with controlled substances.
Oops. Fifth.
Specifically whether Mr. Floyd, his behavior in the car, Mr. Hall previously described that Mr. Floyd was falling asleep, that it was sudden. I would ask him questions about Mr. Hall's previous statements to law enforcement that Mr. Floyd had indicated he did not intend to, or that he was planning on taking these pills later when they got home, implying that Mr.
Oh, he's already given a statement to the police that he was planning on taking the pills later. He's already implicated.
Floyd took them before they left. Mr. Hall described seeing Mr. Floyd go for the ignition when the police arrived, so his behavior's in the car at the time police arrived. Mr. Hall, I would intend to ask him about giving false names to police officers after they were intervened, after the police intervened. Mr. Hall is seen on a security camera taking something out of his backpack and throwing it. I would ask him about those and what it was that he threw. And I would also ask Mr. Hall about his decision to leave Minnesota immediately after this incident. And his
I think we already know the answer to that question, but okay.
subsequent apprehension by the Texas Rangers.
Well, let me.
So it looks like he was taken into custody by Texas Rangers, so he ran to Texas. Why do all these people got ties to Texas?
Let me focus on a couple things. I think you would agree that any questions that he answers about the counterfeit bill falls within his, could
Fifth Amendment.
incriminate him. Would you agree with that?
Yes.
Also, the false information he gave to the police, he would have a legitimate invocation of his Fifth Amendment rights there as well.
Yes.
And what he took out of the backpack, that's a legitimate Fifth Amendment privilege to invoke there.
Yes.
Flight as circumstantial evidence of guilt, you would agree that his fleeing to Texas, if you went into motives, as opposed to simply traveling to Texas, that could be considered incriminating. Would you agree with that?
Yes.
Anything
Use and
incriminating, you
possession
take
of
a
drugs
fifth.
by both of them during that day, that could incriminate him based on counsel's representation. Would you agree with that?
Yes.
It seems like just about everything.
Sounds like the fix is in. He ain't going to testify. You're going to lose a good witness for the defense, and the prosecution can give him immunity to make him testify, and they won't because they know it hurts their case. Again, this trial is not about getting to the truth. It's about color.
Everything that you want to ask him except the following. He would have a legitimate right to invoke his Fifth Amendment rights against compelled self-incrimination. And that being how George Floyd appeared when he was back in the car and the falling asleep suddenly. Would you?
Well, I mean,
And I'm sure counsel is going to say that that's incriminating, but
I do not believe that in and of itself incriminates Mr. Hall in terms
I
of
agree.
the description of Mr. Floyd falling asleep. But the implication being that because fentanyl was found in Mr. Floyd's system, and it causes a person to fall asleep, that would be ostensibly connected to ingestion of controlled substances. So, I mean, remotely perhaps, I would argue, but not in and of itself.
all right. Ms. Cousins, would you? And unfortunately, you don't have the benefit of having sat through all the testimony, but it appears that this would be a proper invocation of his Fifth Amendment rights for just about everything Mr. Nelson was talking about. The one exception appears to be his observations sitting in the passenger seat of the car as how Mr. Floyd appeared, that he was falling asleep and that it happened suddenly. Very narrow. And the reason why I say that is because we have kind of a parallel testimony from a clerk in the store who said Mr. Floyd appeared good-natured, seemed to be having a good day, but he did appear to be high. I don't even think I'd allow counsel to ask whether he appeared high, because that could have formed some kind of opinion and infer a basis that he knew why he was under the influence. But it seems to me that just his description, Mr. Hall's description of, like the store clerk, is not going to incriminate him if there's no questioning about how he had.
Why isn't the judge asking a prosecutor, why are you not willing? Is his testimony important enough to give him immunity? The prosecutor would say no, and I don't know why the judge isn't asking him that.
Why he fell asleep, why he thinks he fell asleep, that there were drugs.
And why aren't we going over what the prosecution subpoenaed him to? What do they want to ask him? Probably all their questions will incriminate him, and they're using this as a side door to get incriminating statements from him.
In the car, that he knew there were drugs in the car, that there was any possession by Mr. Floyd of drugs that day that he saw. If we totally avoid the word drugs and just have Mr. Hall say, I was the passenger in the car, which is already clear. There's video and evidence, just for your knowledge, that Mr. Hall is in the passenger seat and is removed by the police. Beyond that, if established that he was the passenger when the police came up to the car, what was Mr. Floyd's condition immediately that he observed immediately before that? Would you agree that that's not incriminating if we keep all the mention of drugs or why or anything like that?
No, Your Honor, I do not agree that
How
that
would
is
that,
not-
when it did not incriminate the clerk who said he thought he was high, how would it be that
Her answer should be, you already have video evidence of my client throwing something. You have testimony from his girlfriend saying that my client sold them drugs. Now, if he gives any testimony which corroborates his contact or being with them or recognizing drugs, it could be inferred or implied that he knew that because he was their drug dealer. So I think she's got a pretty good argument.
Mr. Hall saying that would incriminate him?
Well, because first of all, Judge, the inquiry is not what evidence is in front of the jury. What testimony have they heard?
No, I'm just using that as an analogy on how that certainly didn't incriminate the store clerk by saying, well, he appeared high.
Yeah, but you didn't have video of the store clerk throwing things and in the car, and you didn't have the girlfriend testifying that the store clerk sold him drugs. That's the difference.
Well, Mr. Hall saying, well, he appeared like he was falling asleep and it happened suddenly without anything else seems to be a parallel type evidence. I was using it as an analogy.
I understand, Judge, but the whole point here is to prevent Mr. Hall from incriminating himself. And him even answering that question that he was in the car puts him in very close proximity with Mr. Floyd, very close in time before he's alleged to have ingested drugs. And again, it exposes him on that third-degree murder charge. If there were to be a future third-degree murder charge, and Mr. Hall was charged with basically being involved in this drug activity that had caused Mr. Floyd to pass away due to an overdose, him even being in that car incriminates him in terms of behaviors of Mr. Floyd, what he observed when he observed it. So, no, Your Honor, I would argue that it definitely would expose him to potential incrimination.
Well,
not to mention, Judge, that this is a car where drugs have been found twice.
Well, and not to mention, I don't really care what you think, Judge, no disrespect. He's my client, and I'm telling him to take the fifth on everything. That's my stance.
Well, and the state has all that evidence. That's pretty clear. And I know we're not talking about, but that didn't incriminate him. The video of him sitting next to George Floyd does not incriminate him, or not has not subjected him to criminal liability, at least yet. So
And
you're
I think
saying
that's
beyond
the,
that
that's the key word, Judge, is yet.
yeah.
Is yet. The
But
question
you
is,
think his observations of how George Floyd looked would incriminate him?
Yes.
I don't see how that would put him closer to criminal liability just with those observations.
Well, I damn sure do, and I bet you the DA does too.
because it then takes the onus off of the state in any future prosecutions to prove what demeanors, behaviors, attitudes Mr. Floyd was exhibiting should they decide to charge Mr. Hall with the crime. Now they've got his own testimony to use against him. That's the very definition of a Fifth Amendment privilege, Judge.
Well, if it incriminates,
Yes.
just the fact that he testifies does not make.
It doesn't have to incriminate. The person can feel it incriminate him, and I can take the fifth even if it doesn't incriminate me. I can just say I ain't answering. And if you want me to answer, then give me immunity. Then I have to answer.
Make it incriminating.
But his testimony would be used to incriminate him in a future prosecution.
Well, anyway, Mr. Frank, do you need to weigh
Anyway means shut up, I'm tired of listening to you. I already made up my mind. We'll see.
in on this? I don't think you have a dog in the fight at this point.
Well, I do, Your Honor, and I would like to be heard briefly.
Sure.
Dude's like, damn, George Floyd screwed me.
Thank you, Your Honor. Our
You're
dog,
not going to represent his interests, are you?
I am not.
Okay,
Our dog in the fight is a fair trial for Mr. Chauvin,
of course.
and one trial. And what we can't have is an invocation of this privilege in front of the jury. And this questioning that the court is offering or suggesting creates a huge problem. And the reason why I cited the Caldwell case to the court is because this questioning would not exist in a vacuum. And we have to remember too that the standard is not just whether this evidence itself is inculpatory or implicates him, it's whether it creates a link. And I think that's partly what Ms.
Understood.
Cousins is referring to is It now puts him in that vehicle, and it's testimony from he himself creating the part
Man, it sounds like he's working for the guy not to be on the trial. It's almost like he doesn't want the guy to testify. Shocking.
of that link. And as I said, it won't exist in a vacuum. There would be other questioning, and we would have the right to question him about his credibility and other aspects of that interaction then that would lead.
Well, Mr. Prosecutor, the way around this appears to be is you give him immunity and we don't have to deal with any of these issues. Why don't you give him immunity?
Unfortunately and potentially to him invoking question by question in front of the jury.
But we regularly, in fact, did in this case, in excruciating detail, walk through motions in limine, limiting what questions could be asked of various witnesses based on rules of evidence. This is not based on rules of evidence, it's based on his Fifth Amendment rights and what could possibly incriminate him. But limitations, and you gotta admit, as Mr. Isaacman and I can tell you, the Caldwell case is a totally different situation. That was a man who wanted to testify despite being warned that everything he said would incriminate himself, and didn't care until he realized it might get him into more trouble than he thought. I think it's the complete opposite of this case.
It's an illustration, Your Honor, of how, despite that witness trying to tailor his evidence to meet a certain goal, it just couldn't be done. And it led to, and fortunately in that case, there wasn't a jury sitting there, but that invocation, that's where they ended up in that case. We can't have that when we're in front of a jury. And Mr. Hall would be faced with the question by question determination of what we're.
Man, it almost seems like he doesn't want Mr. Hall to testify, doesn't it? Shocking.
Arguing about this morning. That's why sort of a blanket invocation is allowed because the standard is rather broad.
What case law says that there is such a thing as a blanket invocation of Fifth Amendment
I
rights?
can't cite the court a case that has yet
Well,
to
and
use
I'll
the
admit-
blanket invocation, but
And I'll admit, I don't think there's clear Minnesota case law on it, but I'm looking at.
The defense should come back and go, Your Honor, they're stating reasons to protect Mr. Hall. My client's on trial now for his life. And this witness needs to be, I need information from this witness to help defend him. What about my client's rights instead of the prosecutor's refusal to give immunity and protecting Mr. Hall's rights? What about my client? That's where the defense should come in a little stronger, I think.
Illinois, the Northern District of Illinois, Oregon, I think Hawaii as well. A couple of cases, just to take a look at Hillman versus City of Chicago, 918 F Sup 2nd 775, which is the Northern District of Illinois. Oregon versus Rodriguez, 301 Oregon Appellate 404, Shackman S.A.
Damn, that's a nice little computer. I wish I had the site he had. Man, the attorneys always had that little special site they go to and find all this information. I'm looking through books and Google and trying to cross-reference to find cases that help me, and the attorneys could always like punch it in and have it in like 2 seconds.
HAKMAN versus Democratic Organization of Cook County, which is 920 F Sup 2nd 881. It's pretty clear from those cases, and granted they're not Minnesota, that the invocation of the Fifth Amendment right is on a question-by-question basis.
Oh, well, then I guess it is. I thought it was all or nothing. I wonder if that changed from state to state. Maybe I'm mistaken. But anyway, if he can go question by question, then put him on a stand. What's your name? That's not self-incriminating, unless he's been given false names, and now he's under oath given his real name, which proves that he was giving a false name to the police. But I think they already got him on that. And again, I mean, the prosecution can give case-by-case immunity. All right, if you give your name, we're not going to charge you with 148. We'll give you immunity on it. What's your real name? Boom.
And the legitimacy of that invocation is to be determined by the court, which makes sense. Otherwise, somebody who just didn't want to testify could say, I'm asserting my Fifth Amendment rights.
That's exactly what I think. If I didn't want to testify, exactly what I would do. And you know what? If you order me to testify, my testimony becomes coerced. and therefore you can't use it against me. So I would absolutely take the fifth on everything and make the court order me to testify, get it on the record that I'm being ordered by fear or threat of being jailed if I don't answer, which makes it a coerced statement.
I agree with that concept, Your Honor. We cited the court a case where they talked about a voir dire process. And essentially this hearing is a substitute for that process because we know from his counsel that he is going to invoke the Fifth Amendment about the very areas she discussed. And there just is no legitimate way. I mean, there isn't really any question that all of the matters that counsel identified and Mr. Nelson identified are tied intimately to his interactions with Mr. Floyd that day and in the previous weeks, and it ties him. So we're not facing a question like maybe perhaps in those cases where they might.
Why are you acting like his defense counsel? Why aren't you acting like a prosecutor and saying, Your Honor, we want him to testify. I would love to have his answers on the record. We want him here. Why isn't he saying that if getting the truth was the goal? He's not saying that because it's not about getting the truth. It's about winning and color.
Might just be invoking because they don't want to testify. Here there is a legitimate link in the chain from what he's going to be asked about and quite a few potential crimes, not just the third-degree murder, obviously being the most important. I mean, we even know, we've talked about the sense of opposing counsel has suggested almost an alternative perpetrator. In that sense, with the third-degree murder, but there's also drug charges, counterfeiting, false information. And I don't know how we put on Mr. Hall to testify and ask him one question and then let him leave without having the ability to pursue, as we normally would in a trial, the credibility and the foundation for that testimony in light of all we know. So I think that this case doesn't raise the kinds of questions that maybe are being brought up in the cases the court cited. I'm sorry, I can't speak to them personally right now, but here there's no question that the singular questions the court is inquiring about are intimately linked to George Floyd and the activities of that day, all the other areas that
Well, I think if you look at the case law, it's much closer to incriminating behavior like the Shackman case. It's really clear that I would have not ruled the way they did. I would have said that was a proper invocation. And they're like, no, it's not a problem.
Well, that's Illinois.
Yeah, let's do this step by step. I appreciate your argument, and I think I know where we're kind of heading with that. This is what I'm going to propose. We're not done today with this. I think we have pretty much established, or based on what Mr. Nelson has said, there's really a very small, narrow topic that might be permissible. So what I'm going to do is I'm going to ask Mr. Nelson essentially to draft in written.
That's what I figured he would do. He's going to only limit him. You can't be sporadic and you can't add. You have to give me the questions that you're going to ask. Then he will give them to the attorney, and the attorney will say, this is why I don't want him answering these. And then they'll agree on a few questions, and they will call him, so he won't have to invoke the fifth, and they will only ask him those 3 questions, and he'll be gone. That's probably what's going to happen.
Question form with the expected answer based on whatever statements were made on what that would be. That way, Mr. Hall can meet with his lawyers and talk about would he be willing to answer those. Then we can have another hearing outside the hearing of the jury where we walk through and see if he would, number one, if I, based on my review of the examination, believe that it is a proper invocation of Fifth Amendment rights to that or not, question by question basis.
Sounds like the judge determines whether or not the fifth applies. Well, I got news for you. If the judge is wrong, the guy walks. So, I mean, I don't, man, that sounds kind of almost stomping on the right, your constitutional right to not answer questions. I'm really surprised that they allow that.
And if I say it's not a proper invocation, is Mr. Hall willing to answer? Despite your ruling, Judge, he's still not going to? Well, he is subject to contempt then. But I think we get too far ahead when we kind of...
If he's in jail anyway, being held for these crimes, what does he care if you hold him in contempt and put him in jail? Fine, I'll take contempt charges. I ain't answering.
Are being vague. Let's say, what are the questions we're going to ask him? Let's walk through outside the hearing of the jury whether or not I would allow it and find that it's not incriminating. And then based on that, Mr. Hall can meet with his lawyers. So I'm talking by Thursday. I'd like that list. The
Which
state
is
can
tomorrow.
do any indication of cross. Same thing. I'm guessing what you would want to cross Mr. Hall on as far as his credibility and all that, well, it's pretty much up to you, Mr. Frank, but I think that since it might widen the net some, so to speak, some of yours might clearly get him into Fifth Amendment issues. But I think we need to, if Mr. Nelson can get you that, you can write up your own list of questions, and let's do it outside the hearing of the jury, and he has time to talk to.
This is a big problem with me in jury trials, is the jury gets so limited. That's why they say if you're 100% innocent, ask for a judge because he gets to hear everything. If you're not innocent, ask for a jury because you only have to convince 1 out of the 12, and the jury don't get to hear everything. So a lot of things that the judge will exclude, which would really help convict you, the jury will never know about. But if you have a judge hearing, he does know about it. And he may say he ignored it, but he knows about it when he finds you guilty.
To his attorneys before we put him on the stand cold, and he has to confer with them one by one. So, and it's a limited, I'm only allowed for that limited, and this isn't a final ruling, this is the only part that I think is possibly not subject to a Fifth Amendment claim. Tell me what you want to ask. We'll run it by outside the hearing of the jury on a question by question basis. The court will make a determination, and then counsel can follow up with Mr. Hall, and based on the court's ruling, are you going to testify? And we go from there. So I don't want this to be the last and try and push through a ruling when we need to tread carefully, obviously. Fifth Amendment right is a broad one, and I agree. The link, you have to worry about links to possible prosecution, but at the same time, if everything's linked, then it's a blanket prohibition, and that is not the case law. So with that, everybody's got their homework assignments. Let's go with that. All right?
Very well. Thank you, Ron.
Alrighty. So it sounds like they're going to do the question. So we'll find out if he's going to testify or not, and if he does testify, it's going to be very limited, which may confuse the jury. And this is the problem, because the jury's all going to be like, this is the guy that was in the video. Why didn't they ask him what happened in the store? This is the guy that threw something in that video we saw. Why didn't they ask him about that? That's the problem with these secret behind the scenes keeping the jury in the dark. And then they'll go, if the jury raises his hand and go, Your Honor, I'm confused. This guy has so much information that I want to ask him, and neither attorney asked him. Why can't we ask him questions? He was there. He saw it firsthand. We want to know what he knows. And the judge will be like, we've ruled on that, and he can't answer. And I mean, it's just BS. I think it ought to be nothing or all, and let him invoke. But you know what? I don't have a robe, so it is what it is. All right, we'll end that there.